Hello, everyone, and welcome to today's edition of Integrating Doctrine and Diversity in the Speaker Series that is now in its fifth year. And this event today is particularly special because it is a virtual coursebook release celebration. And it's a lot of fun. A lot of hard work has gone into a really important product, and we're really proud of it. And you'll hear more about that throughout the next hour. My name is Greg Bowman. I am so privileged and humbled to be the Dean of Roger Williams University School of Law, and I'm going to kick us off with our land and labor acknowledgement. So as we begin today's event, let's take a moment to reflect the lands on which we reside. Roger Williams University School of Law's campuses are located on the ancestral and traditional lands of Indigenous people. Together, we honor and acknowledge the Narragansett and Pokanoket people, nations, as the original stewards of this land. They lived on it, governed it, and cared for it long before the arrival of European settlers. We also recognize that the foundation of this country was built through the forced labor of enslaved African people. The town of Bristol, Rhode Island, including the land upon which our campus stands, was significantly shaped and enriched by the transatlantic slave trade. We acknowledge this painful history and its enduring legacy, and we honor the resilience, knowledge, and cultural contributions of the African diaspora, whose labor was exploited through systems of violence and white supremacy. So thank you again very much for being here. I look forward to today's program. I will turn it over to my colleague, Assistant Dean Nicole Jaslewski.
I saw him struggle there. I know he wanted to say colleague and friend. Um, so welcome everybody. Welcome back. And this is our fifth year of integrating doctrine and diversity programming. The series started 5 years ago with a book release party, and today we are back with another book release party. I would like to profusely thank Dean Greg Bowman and all of the Roger Williams University School of Law family, staff, faculty, students, alumni, many of whom are here and I haven't seen in a while. I also want to make sure to thank our co-sponsors for integrating doctrine and diversity, the City University of New York School of Law, Jurist, the University of California, Berkeley School of Law, and the Anti-Racist Development Institute at Penn State Dickinson Law. Since its launch in 2021, representatives from over 97% of ABA accredited law schools have attended an Integrating Doctrine and Diversity webinar. We have built something, all of us here together, and I continue to be proud of the work that we do and are continue to do. As we start the school year off, I wanted to make sure that I'm acknowledging that the conversations at law schools and really all workplaces on race, diversity, gender, free speech, gender identity, immigration status, justice, and equity are or may be fraud. I want to make it clear that when we have these conversations, I am aware that the people on the Zoom may be experiencing backlash to their teaching, may be feeling disheartened or overwhelmed or abandoned or angry or any or all of those things. I cannot take the feelings away, but my hope is that by continuing these webinars, there continues to be room for these conversations, space for these ideas, and life to this work in and beyond the law schools co-hosting the series. The work of integrating doctrine and diversity continues. Not because I am unaware of what is happening in our country, but because I am painfully aware of what is happening in our country. I hope we continue to have these conversations with the thoughtfulness and grace that we have built here. But I want to change the tone a little bit and make sure that we are now in our celebratory tone. Let us get on to the celebrating. Today is our official launch of our Aspen Casebook or Coursebook, Race and the Foundations of American Law. The book is intended for use in a race in the law classroom, but it is also modular, and chapters can be used to supplement existing casebooks in property law, con law, criminal law, and remedies, and other classes. Um, as I'm in the mood for celebrating, I want to announce or to refresh your memory that here at Roger Williams Law School, we started a new podcast, and I'm one of the co-hosts of it. It is called Law 401. And it is a look into legal issues affecting sort of our state and beyond and democracy generally, from the point of view of a lawyer and a non-lawyer who are talking to people in our state and even beyond our state about some of the issues. So it's really accessible, and I recommend you give it a shot. But I want to start the questions. Enough of me talking. My first question is for Diana Hassel. Diana, can you please introduce yourself and share about the origin story for our book and the class on which the book is based?
Hello, welcome. Nice to see you all virtually. It's good to see when I look at the participants, so many names. Yeah, so I'm Diana Hassel, and I have taught at Roger Williams University School of Law for many, many years. I think we're getting close to 30 at this point, teaching a variety of things, but most recently constitutional law and critical race theory. So the origin stories of our book starts back in 2020 during that horrible summer when George Floyd was murdered, and the conversation about integrating more issues related to racial hierarchy into the classroom became more intense and more urgent. Based in part on pressure from our students, but also pressure from each other, the faculty at Roger Williams Law School decided we have to take a clear step to do more, to talk about not just the sort of dry black letter rule of law, but also where did this law come from? Who does it affect? Particularly with an eye to the history of racial inequality in our country. So a group of us were tasked starting in 2020 to come up with a pilot course, which we did, called, surprisingly enough, Race and the Foundations of American Law. And that was me, Nicole, and our colleague Nadia Humber, who is now at the University of Connecticut. And so for 2 years, we ran as the course as a elective, sort of figuring out how the structure best worked and working through finding materials and figuring out what materials made the most sense. In 2023, our faculty, we also took a bold step and made the Race and the Foundations of American Law a required course, a 3-credit required course to be taught to all second-year students. And so then, since that time, now 3 times, we have the course has been presented as a required course. While those of us who were teaching it were working on this, including at that point, Monica Teixeira de Souza became part of the faculty for that course, we decided it would make sense to put the materials together in a casebook instead of sort of having a hodgepodge of things that we drew from each semester. Let's put together the definitive materials, both for ourselves and future teaching, but to share with others. So the project has started as a pilot course, turned into a required course, turned into this course should have a casebook. And that's so about 2 years ago, Nicole and Monica and I began this project. It was not easy. It was not always smooth, but we are very proud to have finished it and to put this out into the world.
Thank you so much, Di. Monica, can you join us, please? One of the innovations of the book is the 3-part structure. Can you please introduce yourself and share a bit about how we developed this like past, present, and future approach to the course and the book?
Well, it's so nice to be here with all of you. My name is Monica Teixeira de Souza, and I've been a law professor for almost 20 years, but this is only the beginning of my fourth year at Roger Williams. And so I was fortunate to come on to this project, as Diana mentioned, when a lot of the groundwork had already been done. And it was interesting, Nicole, when you mentioned origin story to Diana, because that is very much the way that I think about the structure of the casebook. So when we think about it, we really start with, well, we have three parts. And the first part really does look back in time. It is providing an origin story to the current day. And what we're able to do in that first part is we're able to trace these historical origins of white supremacy in our country, particularly as they manifested through our legal architecture. And when we look at the first chapter, it begins with colonization. It begins with the dispossession of indigenous peoples from their land. And this was a moving chapter that was written by Taino. After that, we move to enslavement, and not only the brutality of that system, a brutality that was legally enforced, but the resistance and the very survival of the enslaved. And that was an important point that Diana, who wrote that chapter, wanted to make sure that we were able to get across. We continue in that first part by looking at Reconstruction. And we look at the promise of equality that existed for a very brief period during that Reconstruction era. And we see its betrayal, a betrayal that occurred largely by our legal system, by our very own Supreme Court. And Jason did an incredible job with that chapter. We leave that first part, that foundation, and we go on to the second part of the casebook, which really turns the students' attention to the present day and to examining how that early history continues to live on in our modern systems that are reproducing inequality, that are reproducing these racial hierarchies that were set into motion centuries ago. And in this section of the book, Diana, Nicole, and we tackle a variety of discrete substantive areas. We look at voter suppression, we look at racial disparities in land and housing, educational segregation and inequality. We look at family separation as a feature of the child welfare system, and we also look at mass incarceration. And each of these chapters is really highlighting how our laws, how our policies are playing an active role, not a passive role, but an active role in determining who has access to opportunity and who is excluded. And we really wanted to make sure that we helped students understand why that legal and historical context matters and why it's not enough to look at modern day racial disparities that may exist, whether it's in regard to educational attainment, whether it's with respect to home ownership, involvement in the child welfare system is another example, and use those metrics alone to perhaps jump to erroneous conclusions about individuals or entire groups of people. And with that, we turn to our last section, the third part of our book, which is really about moving forward, right? It's really about offering remedies, reimagining what our future might look like, a future that could be possible for us as a nation if we were to embrace this project collectively. And I just want to emphasize with that last part, that was really important for us because it was not lost on us that we are presenting this material to students and that the material is, it can be very heavy, it can be very depressing material, and we didn't want to just leave it there with them. We wanted to really talk about what we could do now, right? How do we move forward? And so that became very important in this third part of the book. And what we highlight there are different proposals that honestly the students themselves have been growing up very much exposed to. There are proposals for reparations, proposals that have to do with truth-telling, making reforms to legal education, which is a universe, obviously, that we're familiar with as professors, but that the students are also stepping into. And so we want to provide them with this context, and we want to leave them with a way that they feel empowered and that they feel like they have some agency in shaping what happens next.
Thanks, Monica. I think you did a really great job sort of summarizing the book and also the thinking behind it. I also think we really have confronted the fact that not all of our law students have the same level of knowledge and education about the history of the foundation of like the legal foundation of America. And also there might be students from other countries who literally have no history of this. And so this allows us to sort of level set for the first part and just say, hey, let's all get on the same page. These are things that happen as we sort of investigate the modern day systems and then dream about the future, while all doing that, knowing that we're going to be lawyers and lawyers have this sort of unique role in this system. Monica talked a lot about collaboration. I just wanted to see if you wanted to chime in at all on sort of the topic of collaboration and how that worked out within the book.
Yeah, I think from the very beginning, this has been really important to us that there be many voices in this project. Just the fact that there's three of us as co-authors is one representation of that. We, the three of us, Monica, me, and Nicole, have different histories, different strengths, different skills, different knowledge bases. And we thought it really made sense to not have the book come from one point of view, but from as many as we could. And so in addition to the three of us sharing our differing ideas, we also very consciously reached out to other collaborators to write certain chapters. So as has been mentioned before, Taino Palermo wrote the chapter on colonization. Taino is an expert in Indian law and could bring all of those perspectives, both his academic and social and personal perspective to that. We then had Justin Precepts, a practicing attorney here in Providence, who has a deep historical background in studying this material, write the chapter on Reconstruction. Then another one of our colleagues, Natasha Variani, who has also been working in related areas, wrote a chapter on legal education. In addition to those chapters, we also had the collaboration from Bernard Freeman, the director of our Race and Law Institute, who is an expert on contemporary slavery and human trafficking, write an essay that's found in the slavery chapter. And we had Dean Danielle Conway write a foreword. The dean of Penn State Dickinson, write a foreword to the book to put the work that we were doing into a larger context. She, of course, is one of the founders of the Anti-Racist Development Institute. So, all in all, we have 8 different voices running around in this book, and that was very much by design and very much hoped to open this up to a lot of different perspectives and a lot of different ways to approach this material.
I think that you're right. I think there's also these sort of other people who were collaborators, the people who teach in the class and who have taught in the class over the last 3 years, definitely gave feedback about what we should be teaching, how we should be teaching, what we should include, and also the students. So it is not lost on us that the class became a class, not just because of the vote that the faculty and staff and administration here made, but because the students of the Black Law Students Association demanded it. And so we also were very clear. Some of our old TAs are on the session. We sought input from anyone who was willing to give it. and who was kind enough to say, yeah, but okay, include this. And I know that, Diana, one of the things that I think you really brought to the team was remember to talk about not just what happened, but also the resistance to what happened and the sort of life making despite how horrible some of the history is. And so there's like even more collaborators beyond the ones that are whose voices are actually in the books. And so now is a good time to talk to one of those collaborators, Ty. Ty wrote the first chapter. Can you please introduce yourself and share what your chapter is about and what your approach to the materials were?
Sure. Thanks, Nicole. Yeah, so my name is Taino Palermo. I am an attorney practicing education law, nonprofit law at Barton Gilman. I also am the co-founder and co-director of the Center for Indigenous Peoples' Rights, which is the East Coast only full-service pro bono law and policy center servicing Indigenous peoples and tribal communities. And I am an alum of Roger Williams Law and had a career at Roger actually before law. And so I have an academic background and had collected a lot of this material in my own personal and professional capacities in my career prior to law. I actually left my career to go to law school to actually formalize my understanding and training as it relates to Indian law and Indigenous people's rights. And so upon the creation of the center and now being entrenched in Indigenous people's law and policy from the East Coast to representing clients in Hawaii, it kind of was a calling, so to speak. So Nicole and I have a pre-existing relationship where she asks and I just say yes. And she had asked if I had wanted to be involved in the development of this case book that her, Diana and Monica were leading. And I taught and do still teach the second week of the course, which is was previously basically around colonization, but it was more of a federal Indian law kind of dip your toes in the water of this area of law because it's actually foundational to the founding of this country. And so it kind of took shape into this broader understanding of colonization as it relates to the informing of the American legal system. So when they asked me if I wanted to contribute to the book, I was like, absolutely. And they said, great, you're the first chapter. And I was like, whoa, that was a lot of weight. But it was also an exciting opportunity to really kind of coordinate all of these efforts that I have done and been a part of in my personal capacity. Generationally, I come from a family of advocates for independence and recognition as Indigenous peoples. I come from a generation currently of just folks on the ground who have been advocating for Indigenous people's rights in modern times. And so I was already kind of tuned into this. Now I had the formal legal training, and I had written, academic things in the past. So this was a very exciting opportunity to bring all of that together. Now, the chapter itself, knowing that, the layout that Monica described, I had a fairly sizable universe to operate in, and knew I didn't want to go too off the rails. Plus, Nicole, Diana, and Monica were great at kind of helping carve away the fat, so to speak, so that we had a really tight, lean product to present. But the chapter kind of allowed me to really put ink to paper, so to speak, on what I knew to be the case and what I had from all these other scholarly resources. It was an opportunity to thread it all together. So the chapter starts with the understanding of kind of history. The world at the time was ruled by the global powers that were monarchs, kingdoms, and and queendoms, and these monarchies whose authority all flows from the church. And so we kind of ground readers in the fact that the legal, quote, legal authority at the time was by religious executive orders known as papal bulls that eventually give license to world powers to expand the quote unquote Christian faith and conquer anything in their way, including the subjugation of early iterations of infidels and savages being used as references for indigenous peoples or non-Christian, non-European peoples. And so we see those, and we intentionally highlight those terms from papal bulls all the way into Supreme Court holdings as recent as the 50s and 60s. And so, you know, that through line is intentional. And so we start with papal bulls, and the first kind of case that ever references that those papal bulls and this ideology of white supremacy and European supremacy in particular, in a case called Calvin's case. And that kind of sets us up for what becomes adopted in our first series of cases in federal Indian law known as the Marshall Trilogy. And that's important because that's really what sets the stage for displacement, takings of land, and eventually the subjugation of the indigenous people of this country. And then it kind of grounds itself into the emerging pseudoscience at the time, because in the area of law, we are heavily reliant on experts. And so if the medical and science community is also substantiating the ideology of white supremacy, then the law is obviously going to follow in lockstep. And so with that in mind, you know, we dissect cases that kind of perpetuate this superiority over indigenous peoples, and kind of sets it up for the subsequent chapters that will be discussed around this ideology. But when we stick in as it relates to the colonization aspect, we wanted to be clear that we kind of encapsulate a mini past, present, future theme that Monica referred to broadly for the book, and as it relates to colonization. So we bring all of the aspects of colonization into modern day with, you know, the exploitation of environmental resources, the exploitation of labor, the exploitation of taxation. You know, we see these things in Puerto Rico, the Marshall Islands, the history of Hawaii and the Philippines, and then we bring it, you know, we kind of bring it home with efforts of resistance, past and present. And so, and then along the way, we have these little tidbits to dig in more. So my approach was really being able to thread all of these things together, and kind of follow that through line of how we got here, how it has informed our system, and what it looks like now and going forward.
Thanks, Ty. I think the students are consistently surprised about what they do not know or what they were taught, and the chapter sort of unearths that maybe the things they were taught were not completely true or were biased or one-sided, and what they weren't even taught in law school up to this point about Indian law or colonization or settler colonialism. And so I think it really packs a punch. And you can imagine if that is where we're starting with the book, the tone of the class is really set from the beginning. Another one of the sort of innovations of our book is we on purpose chose to have an author, at least one, who was a practicing attorney, even though this is a doctrinal and not a skills book. Jason is our author, although some of us also practice on the side, but are mostly academics. Jason, can you please introduce yourself and talk a bit about your chapter and your approach to the materials?
Oh, sure. Hi, I'm Jason Precyphs. I'm an attorney practicing 23 odd years in Rhode Island and Massachusetts. I have a wide-ranging practice. Among other clients, I represent the city of Providence, having successfully argued in front of both the Rhode Island Superior and Supreme Courts for the right of existence for the state's first police civilian review board, the Providence External Review Authority. My obsession has always been with Reconstruction and the second framing of our Constitution. After 2 years teaching a different course as an adjunct at RWU Law, I jumped at the invitation to join the team that teaches this course back in 2022. And with this chapter, the approach I took was to try and illuminate the period by illustrating its successes and its transformative nature, and also to try and contextualize the Reconstruction amendments and the related case law, both case law that built on the amendments and case law that undercut the amendments and the process of Reconstruction. Photographs from the era were important for me to try and give life to this material. I also wanted to explain some of the background of many of the key actors from the period, and to try and show some of the history that's been largely swept away. I also wanted to try and tee up some of the sections and some of the topics that are later addressed in the book. My hope was that the readers come away with a sense of what I'll term the far swing of the pendulum can look like for this country and this Constitution. Well, without the help of the authors, this never would have happened. I so appreciate their ears, their eyes, their encouragement, and seeing the final product come together. It's just it's so amazing to have been a part of.
Thank you so much, Jason. We are so thankful that you were willing to join us. So the book, as you've heard, is more of a course book than a case book. We intentionally included materials beyond cases, like pictures, artwork, poetry, settlement documents, statutes, and much more. We also included these like call-out boxes with legal skills information, because we understand how important integrating skills in doctrine are in the next gen bar, and beyond. We have a deep and abiding respect and adoration for the other race in the law books and authors, and wanted to complement what was already out there in the field. So the next person to speak is Elizabeth, who I would probably say is more like a saint or an angel. So Saint Elizabeth, or Elizabeth the Angel. Can you please introduce yourself and talk about some of the details in the book that make it stand out from the other race in the law books on your shelf at Aspen?
Absolutely. Thank you, Nicole. My name is Elizabeth Dobkowski. I'm one of the managing editors at Aspen Publishing, and we have just been absolutely thrilled to work with this author team and on this book. I'll just start out by saying we were moved by the author's ideas for a richly textured course book, case book, and the diverse experiences and expertise of the whole author team, the authors and contributors. And I think that, we have, as a big team, the authors have accomplished what they set out to do, to complement and bring something new to this, to the offerings in this area for in legal education. So it can be a tall order to bring all of these various things together and still do what case books or course books do, which is teach doctrine and skills, which this book in particular, and everybody's mentioned it, kind of the overall framing of past, present, future, and various pedagogical elements, including, literature, images, art, and kind of striking that balance where we're also looking to, have it be sort of helpful among various learning styles too. We feel that we were able to kind of have consistent elements throughout so that we were, that both adopters and professors and students were finding, a pattern within each chapter. But what's new and great and does kind of set this book apart are those various elements, but as well as, we ended up coming up with call out boxes for time out for practice. There's more to the story, want to learn more, in addition to the cases, excerpts, notes, and questions that, everybody's very familiar with. And so I think that's, that kind of puts a bow on the content. And, there is, it has a great place within the catalog. And we're very, very pleased and really appreciative of everything that everybody's contributed to the book.
Thank you. That was very understated. You didn't at all talk about how I cried because I couldn't imagine. It is so hard to do all this work and then like birth it into the universe. And I don't think that it would have been possible without you, who was like a steady presence when we were doing the hard work and really in it. And I also think like it is really hard to explain how living with a chapter, writing a chapter on mass incarceration over a period of months just seeps into your soul. Like when you're like listening to music and you're listening to podcasts of about people who are currently incarcerated, when you're listening to the history of incarceration, when you're listening to all of these things, it's your life. You're living it. Like there's no like, our full-time jobs are to be teachers. And then on the side, we're doing this and we're also trying to like live our lives and, see our families, but it pervades everything you do. And you were so calm and kind during the entire process. And so you to me, you are a saint.
Well, thank you, Nicole. I mean, it really is an honor to help, support a project, especially like this. This is an area that is, it's hard going for writers, especially, and to be immersed in it and, and try to push on through to get it done. And also we've got these deadlines and these other sort of like realities of the situation, and you all just did beautifully with it. And so we're really happy for you and really happy to celebrate with you.
Thank you so much. And the world radically changed in the last few years. And so I knew, so Monica, my next question is for you. Most people right now are not teaching race classes. Many schools are not currently offering these classes, and if they do, they're not required, although there's still a handful of schools that do have required classes. But what I think is so helpful about our book is that it's modular. We intended that some of the chapters could be used, could stand alone as supplements to existing textbooks and classes. As a property law professor, how might you use the housing chapter to supplement your existing property law class?
Thank you so much for that question, because property is one of these areas that I have taught for a long time. It's been my course since I first started teaching. And I've thought about how I would put together this chapter that, in the way that you said, would be useful to professors that don't necessarily have the benefit of being able to teach a standalone class on race and the law. And the key was to try to make it flexible, but also to try to make it relevant to the present day. And so one of the things that I should mention is that even though I've been in the academy for so long, I started out as a legal aid lawyer. More recently, I developed a housing policy clinic. And so I'm always thinking about what are the issues that are happening out in the community that students might actually have to deal with when they graduate and start practicing law, and how do we embed the materials, the academic materials, with information that's going to be useful to them. And so with this chapter, I tried on the one hand to connect to the topics that they will have been exposed to in a 1L property course, but I expanded upon those topics. I also try to cover more context, and I try to use that same framework that we're using throughout the book to basically show some possibilities of moving forward with this material. So for instance, there are a couple of themes that I included. One is the way that ownership of land and ownership of housing has been really central to wealth building and to the intergenerational transfer of wealth. And so a number of the materials that I explored in this chapter would be useful to a professor who is hoping to convey that aspect of our system to students, no matter what year of law school they're in. There were other topics that are covered in other sections of the book that I also revisited in this chapter. So when Taina was talking about his chapter, one of the things that I did in the housing and land chapter is that I looked again at Indigenous dispossession, particularly looking at the Dawes Act. But I used a more modern setting, which was to talk about the highly fractionated state of Indian title today. In other words, the way that many Indigenous people own land, where they hold a very infinitesimal percentage ownership interest in a particular parcel of land, and it actually is linked very much to the history, to what was done through our legal system, but it also explains the problem with ownership and wealth building in the Indigenous community in the present day. We also, in this chapter, I talked quite a bit about some of the history that students would have been more familiar with from their 1L year, such as racially restrictive covenants. But I focused more on other issues that maybe aren't usually covered as deeply. Displacement of communities, particularly Black communities, Latino communities, low-income communities through urban renewal projects, through the siting of federal highways. And we also explore eminent domain. And eminent domain is often talked about in the context of the 1L year, but for those of you who remember, usually you're covering Suzette Kilo and her little pink house, and you're not necessarily delving into the way that eminent domain has been used disproportionately in communities of color. And that ties me into another piece that was important for me to highlight in this chapter, and that was a way that we could really talk to students about less familiar histories that often aren't talked about at all in the 1L year, or really sometimes at all during law school. So for instance, I talked about ordinances that confined Chinese Americans to segregated districts. I talked about this episode called the Chavez Ravine episode in California, where Mexican American families were actually displaced to make way for the building of Dodgers Stadium. And this was very intentional on our part because we know that we are teaching a classroom of students, and we wanted all of our students to really feel that their histories are being reflected in the materials. And so very much we were trying to go beyond a black-white binary when we selected stories for this book. And then finally, the last thing I'll say is that piece about bridging all of these stories into the present day was incredibly important. And one issue that we highlighted in this chapter was that of discriminatory home appraisals, which is something that typically in a standalone property law class we don't get to, but it's so important in actually looking at now specifically the persistent and salient anti-Black racism that continues to exist in the realm of real estate and property law. And I use this one phenomenon, which is that Black families often are whitewashing their homes. In other words, removing all markers that the home is Black owned in order to try to ensure that it is being appraised at a price that is comparable to that of their white neighbors. So there was so much, I can relate to Jason and Taina when they're saying it took a lot of thought to try to figure out how do you take these topics that in and of themselves can generate an entire book and put them into one single chapter. And so that's part of what we really try to do. And I hope it will be useful to a professor who maybe can utilize it as a supplement, bring some of these stories in to their students.
Thank you so much, Monica. And now from one property professor to another, I would like to introduce Natasha. Last but not least, let's round out the team. Natasha, can you please introduce yourself and discuss your approach to your chapter?
Yeah, so I'm so thrilled to be here. My name is Natasha Veriani. I have the distinct privilege and pleasure of teaching at Roger Williams University School of Law, though I do not teach in the race class. I do teach in the area of property with my colleague Monica. And I was lucky enough to contribute the chapter about legal education, and really mindful of this sort of three-tiered framework of the book, understanding that my chapter sort of came in that last tier. There were a couple of things that I had in mind. Mine is a teaching style that sort of really reflects a lot of what these panelists have said already, and that particularly Monica, and I want to really sort of, a lot of what she was saying, I was sort of very vigorously nodding. The stories of our students are really important. She said something about really reflecting the history and the stories of our students' communities. And that's really important for a lot of reasons, right? Just because it's the right thing to do. But there's also another reason, and that's because it sort of really helps the doctrine stick with our students a little bit more. And so when I was writing this chapter on the history of legal education, I'm also thinking about making connections to the chapter that Monica wrote on education law. And so there were a couple of things that were happening simultaneously. I'm bringing my own personal story to sort of this doctrine and a critical lens to what's happening. The sort of main part of the chapter has to do with this decision that was recent when the casebook was written, the SFFA decision that deals with affirmative action and this court. But I was writing it sort of with the knowledge that though it was recent when the casebook was written, I am feeling like in the line of history, I know it's going to be sort of it's going to be a marker in a sort of in our legal history. So I was trying to provide a picture of what the history of affirmative action was like, and how we got to how the precedent sort of got to where it did, right? We have sort of a very clear through line, and how different communities were affected, because it was really, it is a very American story, particularly as different racial groups interact with each other, and have been used, and sort of how the affirmative action how affirmative action was initiated, and how it evolved, how the debate evolved in sort of our cultural context, and how the legal context, how the court sort of started viewing it. And so balancing sort of the cultural moment we are in with sort of the legal history was sort of a difficult task. I am not a teacher in this course, which is one on race and the foundations of American law. I previously have taught a course on critical race theory and the law, which is a different doctrine, but it was useful for me to have that lens when I was writing this chapter. But I think for me, it was most important to use a tone and a voice that was one that would resonate with the students and that would stick with the students and would make them sort of see and feel in a really visceral way their place in this profession, make them feel empowered to sort of take the mantle of not just this issue, but sort of understanding that their ability as lawyers was really particular. Their sort of influence as change makers, to use sort of the Roger Williams. It's more than just the Roger Williams phrase. It's one that I sort of really think is impactful. That as lawyers, we have a disproportionate impact on policy. So that was a really important part for me of this chapter, particularly understanding that my chapter sort of came at the opposite part of the book as ties at the end. I really wanted to sort of end on this, to sort of have the book conclude on this note of, okay, here's welcome to this profession. What are you going to do with this power that you've been given, with this privilege that you have of a legal education, and really make them understand that they should bring all of their identity, and that diversity was strength. It was particularly important for me, despite taking up a lot of space in the chapter, to include some of the dissenting opinions for the SFFA case, because it is not just that there are a lot of different types of diversity. We have 2 Black justices on the Supreme Court who wrote opinions in the SFFA decision. And we see that it wasn't just that there were a lot of different ways that someone who was Black could approach that affirmative action decision. So I really wanted people to understand that all of their identity could inform their opinion, and that that's what they should bring to their power as lawyers, because that's what inspires me, and that's what I hope will inspire my students. And I also wanted to mention that if people are looking for resources, particularly in first-year classrooms, I also wrote a supplement called Owning Our Values. I know it can be difficult in these times, but for property classrooms in particular, if there are people who are looking for additional resources to supplement some of the sort of more traditional property law doctrines, I wrote this with the hope that it would help both students and professors to sort of fill gaps where possible.
Thanks so much for talking a little bit more about your choices. I think the past, present, and future structure is pragmatic in the sense that it is really hard to teach a group of people about the horrors of sort of the twin founding injustices of colonization and slavery, and then say, oh, and this is still playing out today, and then end it. It needs to go somewhere. And so the class has this arc, and it ends on positivity or possibility. But there's also the issue of, you know, these people are joining our profession, and there's what Natasha said, you picking up the mantle, and then also sort of, particularly in the section about legal education, thinking about 100 years ago, many of our current students wouldn't necessarily be in law school or have access to law school, and even if they did, it wouldn't look the same as it does today. And so it's not just legal education wasn't necessarily created for all of us, but at this point, we're creating this space that, in my opinion, should have been there the whole time. And I think that future section is really important. I do want to take a question from the Q&A, which is, congratulations on this casebook. What is something you learned during the project that you did not expect and that you hope readers take away? And I am open to anyone answering that question. So if you want to answer, if you want to come back on the screen and unmute yourself, I would say for myself, I learned a lot more about Indian boarding schools or indigenous boarding schools, Native American boarding schools, and I was able, through my work with the Anti-Racist Development Institute, go to visit them at Dickinson Law in Carlisle, Pennsylvania, and visit the grounds of sort of the premier American Indigenous boarding school. And I think the history of assimilation of Indigenous people is one of the things that I learned the most and would encourage everyone to sort of learn more about, because I think it makes things that are happening now in law and in society make more sense. Di, what about you?
Yeah, I just wanted to mention briefly, I spent a lot of time finding out more about the institution of slavery and what enslavement meant. And while I knew a lot about the hardship, I learned so much more about the rebellion and the resistance that has not been talked about as much, both the continuous sort of refusal to cooperate and bravery of enslaved people, but also groups like the Maroon community, which we learned about, which were groups of enslaved people who had escaped and created their own separate, completely independent communities out in the wilderness areas that existed. And just the sort of human spirit of making something out of nothing, making hope out of despair was really inspiring to me. And there's so much more to learn in that area.
Thanks. My second to last question is to anyone who chooses to answer. What advice do you have to give teachers who choose to adopt this textbook during these tumultuous times? And or how do we talk about race in a climate of fear and distrust? It's a big, scary question. Does anyone want to hop in on that? Ty, take it away.
Yeah, I can happen. And I think, I come at this as someone who teaches federal Indian law. And I preface the course on day one with, in this course, you have to hold two truths. There is a very real, ugly history of this country, and there is an avenue of equity and justice by which Indigenous people in this country can achieve. And so I think one of the things, if you teach federal Indian law, you know that there is no the peace of mind of tribal communities doesn't exist with any one particular political party or governmental administration or who is in the Supreme Court. It is a very volatile and unstable body of law. So when you zoom out to this broader context, I think it is certainly easier from a civics and or historical and or like legal technical education way to approach these very otherwise provocative topics around race, because we are resting on cases, we are resting on historical fact, debunked pseudoscience theories. And so we have the hindsight of 2020, but also the fact that we're not we're not injecting any layer of, I mean, you can stylistically as a professor, but you don't need to inject any layer of interpretation. It very much speaks for itself when we're talking about in the colonization chapter, that Justice Stanley Reed says every American schoolboy knows that the Indians were savages and they traded land for trinkets. That's a Supreme Court justice in 1955, just casually saying that, and followed, in the next chapter with Dred Scott and Black people are not citizens, and so the history kind of just speaks for itself. You don't really have to embellish it or feel like you're pushing some sort of agenda, because it is historical fact rooted in actual law. And so I think from this perspective, it can be less contentious or provocative, by simply delivering it straightforwardly.
Yeah, I totally agree. I also think there's this element of it's been there all the time, that choosing not to have these discussions is a choice. It's not it's not the default. It doesn't have to be the default. It's a choice to discuss these issues or not to discuss these issues, and we're just choosing to discuss the thing that's already there. Did anyone else want to jump in on giving advice to people who are talking about race in a climate of fear and distrust? Jason, you're up.
I believe we have to talk about race. We have to do it respectfully, with patience, hearing not only the words, but listening beyond the words to the emotions that are brought to the discussion, that are fueling the discussion. We also have to be prepared to ground our discussion in fact.
Thank you. And I think that that's a really good place to end this, because it gave us all something to think about as we sort of move to our next meeting. I want to say thank you to all of us who are here today, not just those who are speaking, but those who are behind the scenes, the law schools who support this initiative, to all of you who attended, especially to our alumni who sort of helped grow this class, and including our TAs. I see a few of you in the chat. We love you and miss you and thank you. I also want to make sure to say thank you to Dean Danielle Conway, who wrote the foreword. Thank you to Kathy and Elizabeth from the Aspen side, and so many other people from the Aspen side. Thank you to our families who put up with people who are stressed out sometimes because we believe this is our calling and the right thing to do. And I hope that you are looking forward to our next Integrating Doctrine and Diversity, which I think is going to be a real banger in New England parlance. And please, the Anti-Racist Diversity Institute at Penn State Dickinson Law has their annual convening in October. I recommend you go on their website and check it out to see if it's something that might work for you. The dates are October 8th through 10th of 2025. And also please check out the Law 401 podcast. Give it a listen. It's a fledgling podcast, and we're so excited for any of our fans to like us, subscribe, email, and we'll see you again next month. Thank you to everyone.